is criminal. o ko e ko ka aha. I nā he kuliana I mua o kea aha ho o kolo ki e hano hano o ka moku aina o Hawaiʻi. I naoi mai, I malio mai, I lohe ia ka leo. Hear ye, hear ye, hear ye. All persons having any business before this Honorable Supreme Court of the State of Hawaii, draw nigh. Give your attention and you shall be heard.
Please call the case.
Case number SCWC 2153, State versus Jardine. Arguing for the petitioner, State of Hawaii, Stephen Tsushima. Arguing for the respondent, James Keone Jardine, Emmanuel Guerrero. Argument on the merits.
All right, good morning, aloha everyone. This proceeding is being broadcast live on the Judiciary's YouTube channel and on Olelo Channel 49. The court is honored to conduct this oral argument as part of our Courts in the Community program, our second virtual event as part of that program. We'd like to welcome the students and teachers from Aiea, Moanalua, and Molokai High Schools who are watching. During the proceeding, should a justice have a question, they'll raise their hands virtually and I will call upon them at the earliest opportunity. I'll ask our attorneys to introduce themselves in the order in which they'll be arguing.
May it please the court. Deputy Prosecuting Attorney Stephen Tsushima on behalf of the state.
Thank you.
Thank you, Your Honors. May it please the court, Emmanuel Guerrero on behalf of the respondent, appellee, Mr. Jardine. Your Honor, Mr. Jardine is not appearing today, but he is watching via the YouTube link. Thank you.
All right, thank you, Mr. Guerrero. Just to confirm, Mr. Tsushima, you'll have 20 minutes for your initial argument. You reserve 10 minutes rebuttal. Mr. Guerrero, you have 30 minutes and you'll receive a 10-minute warning. And for both of you, at the end of your time, you'll see a light come on and you'll also hear a tone to signify the end of the 30 minutes. Mr. Tsushima, please proceed.
Thank you and good morning, Chief Justice. And Associate Justices, good morning to you as well. The issue before this court is whether the state was required to include in its charging instrument the statutory definitions of substantial bodily injury and or dangerous instrument for the offense of assault in the second degree. In this case, the defense filed a motion to dismiss the felony information based upon a defective charge. My office filed a memorandum in my opposition where it pointed out, amongst other things, that this court is not confined to the four corners of the charging instrument, but may look to other materials given to or obtained by the defense, including the discovery in this case. Nevertheless, the trial court did grant the motion to dismiss, and the ICA affirmed that order. We filed an application for certiorari to this court, which this court accepted, and which brings us to today. But perhaps I'm getting ahead of myself. With the court's indulgence, I'd like to give a short summary of the underlying incident which brought us here. That was an argument between the defendant and the victim over money owed by the victim to the defendant. This was detailed by the defendant in his statement to the detective, which was the detective's closing report was attached as an exhibit to the state's memorandum in opposition. In that statement, defendant said that during the argument, the victim actually threatened the defendant and threatened to go get a gun to shoot him. Several days later after the argument, the victim did text the defendant to let him know that he had the money that was owed to him. The defendant explained to the detective, though, that he was having problems with his hips and difficulty walking. So he used a metal baseball bat to use as a cane. He went to the victim's house and knocked on the wall and called for the victim. According to the defendant, the victim exited the house angry and said, "What do you want?" According to the defendant, the victim rushed towards him and he backed off. The defendant stated that he held up the bat in front of him to ward off the victim. He did admit that he swung the bat to the lower portion of the victim's body, but denied that he ever swung the bat hard, denied that he ever intentionally swung the bat towards the victim's head, and did not know how the victim got his injuries. Nevertheless, the victim did suffer fractured skull and a serious concussion, and defendant was charged with assault in the second degree. As I had mentioned earlier, the trial court had granted defendant's motion to dismiss. And in doing that, the trial court laid out the issue that's before this court. At this point, I'll be reading from the transcript of that proceeding as it laid out the issue. The felony information herein, filed August 28, 2019, charged defendant with assault in the second degree via two alternative means, alleging that defendant intentionally or knowingly or recklessly caused a substantial bodily injury to the complainant in violation of 707, 711, subsection 1, subsection A, and or that defendant intentionally or knowingly caused bodily injury to complainant with a dangerous instrument in violation of 707, 711, 1D. Defendant has challenged the information as defective for not providing fair notice to the defendant regarding the elements of the offense because it omits the statutory definition of substantial bodily injury and dangerous instrument. The trial court noted, where the criminal defendant challenges the sufficiency of a charge in a timely manner, the charge will be upheld if it, 1, contains the elements of the offense, and 2, it sufficiently apprises the defendant of what the defendant must be prepared to meet. The relevant inquiry is whether or not the charge has provided the accused with fair notice of the essential elements of the offense charged. Essential elements of the charge include conduct, attendance.
Mr. Tsushima, if I could, the statute has 5 very specific definitions of substantial bodily injury, which the charge didn't include. And I think that's part of the concern there, that, the language of the statute without the definition is very broad, and somebody may not understand that it has to be one of these 5 very specific types of injury. What's your response to that concern?
Well, I understand that concern, but it's my understanding reading MEDA that as long, that the common understanding of the term is broad. What we would want to look at is whether it's consistent with, comported with, or coincided with the common understanding, the statutory definition that is. So those 5 things, if they fall under what would be the common understanding, then there isn't a problem or concern. At least that was my understanding reading MEDA and the examples that MEDA gave for that was animal nuisance.
Justice Wilson has a question. Justice Wilson.
Thank you, Chief Justice. First, Mr. Tsushima, could you help me with which of the 5 categories of assault 2 was applicable here?
The 2 that I spotted, and which I mentioned in my summary, was a bone fracture and a serious concussion.
Okay, so the provision pertaining to section 1, avulsion, laceration, or penetration, that wasn't applicable?
Correct. I don't believe
so. Your thought is that this does sufficiently apprise the defendant, where the defendant has to sort of select which one, and in your view, there are 2 different ones that apply, right?
Correct.
Okay, well, in considering whether or not the definition of substantial bodily injury, the commonly understood definition, is as specific as the statutory definition, what about if this caused bruising, like bruising that was very extensive throughout the body? Is that substantial bodily injury?
No, I don't believe it is.
Right, so it just seems as though the common understanding of substantial bodily injury is greater than the specific statutory definition. So wouldn't that mean that you need to give some definition in the charge so they know, 1, which of the categories of assault applies, and secondly, what the facts are that would suggest that assault 2 was actually committed, since, the common understanding of the facts would be greater than the facts that actually apply under the statute?
Well, my answer would be no for two reasons. The first being that, using your example with the bruising, if it's bruising and it's any number of injuries that are otherwise part of the broader understanding, common understanding of substantial bodily injury, it wouldn't harm defendant that also could suffice. When included with what he did was a bone fracture and serious concussion, which does qualify as substantial bodily injury. And the reason being is because, as I had mentioned earlier, part of what this court can and must consider are all the things before the defendant. So he's claiming that he wasn't given sufficient notice of what the charge is against him or what he has to defend against. Our position would be that when the court looks at the closing report and where it states specifically that the victim had suffered a fractured skull and a serious concussion, that it's then made clear to the defendant that notwithstanding any bruises or other injuries, that's going to be what he's going to have to face.
Okay, then the common understanding of the term substantial bodily injury doesn't really matter as long as there is a factual basis that can be gleaned by the defendant that would meet the statutory definition. Is that your view? So you think our standard shouldn't take into consideration the common understanding of the definition?
In that it's broader. I think this court should consider it because if it's broader, but yet the statutory.
I thought you were saying it doesn't really matter if the common understanding is broader. If you look at the discovery and the discovery facts fit the definition in the statute, then that's enough. But that's not your position.
Perhaps I misspoke. When I meant it doesn't matter. It doesn't matter if the statutory definition or the factors that we're looking at, the 5 types of injury, fall within the common understanding. What I mean by that is when I'm reading this court's cases, when I'm looking at Mita and Kalhane and Wheeler, when we're saying common understanding, well, there is a subjective component to that. But what we're saying, I believe, or I'm gathering from this court's decisions is it's a common agreement, a common that these factors do fall under this definition or this phrase, in this case, substantial bodily injury, so that there wouldn't be disagreement that a skull fracture or a serious concussion is a substantial bodily injury.
Mr. Tsushima, we have questions from Justice Edens and then Justice McKenna. Justice Edens.
Thanks, CJ. Mr. Tsujima, you say that the statutory definition of substantial bodily injury, and I take it also dangerous instrument, is consistent with the commonly understood meaning. Now, and you agree, I mean, that's your point, right?
That is my point.
Now, looking at dangerous instrument, in 707-700, the statutory definition is really broad. I mean, it's very broad. And it says, as you know, in the manner it is used or is intended to be used, is known or to be capable of producing death or serious bodily injury. So I want to examine the common ordinary meaning of dangerous instrument. What is the common meaning of dangerous instrument? Well, that seems to be a tool or an implement for scientific work, an instrument. Or I think if we asked our students today what they understand the ordinary meaning of a dangerous instrument to be, some might say, particularly, especially maybe band members, that, you know, in the hands of an untalented musician, a trombone or a harmonica can be a dangerous instrument. And, you know, so I guess what I'm asking you is when we look at ordinary meanings, how does the 707-700 statutory definition comport with the common meaning of the term dangerous instrument?
Well, I would argue for the reasons you just pointed out, that the last part of that definition does describe, and that last part which you said is the manner in which it is used or intended to be used is known to be capable of producing death or serious bodily injury. I think that does fall in line with what we would commonly agree, that it's a 2x4 is not necessarily standing alone a dangerous instrument, but it's the manner in which you use it or intend to use it. If you swing it towards somebody's head, if you just poke it towards their chest, maybe it's not a dangerous instrument. But that the statutory definition does coincide with what our common understanding would be, so that if we ask one of the students, would you agree with that it's the manner in which it's used, that they would agree.
Okay, so you would not then focus on the actual term dangerous instrument. You're focusing more on the statutory definition. But let's say, say a person with a pen, they could poke somebody and cause bodily injury, but that person might not necessarily understand what the dangerous instrument in the charge refers to, because the normal person might not think of a pen as a dangerous instrument. And when I look at Kauhani with obstructing and the statutory meaning of that, and King and the confidential personal information, the statutory meaning, did it comport with the common meaning? I mean, it suggests to me that, don't you think that the law suggests some sort of an alignment between the statutory and the common meaning, and that being key as to whether a charge sufficiently apprises a defendant of what they must defend against?
Right, and I agree with you, Justice Edens, and I see that that's part of what makes this difficult. It's not easy. It's not an easy breakdown of where the statutory definition does not completely coincide or comport with the common understanding. With this issue, with the definitions of substantial bodily injury and dangerous instrument, the main thing my office wants to know just once and for all is, does this court take the stance that we should put it in the charge instrument?
Let me ask you this, thank you, Mr. Sujima. Peking gives you the answer. This is what Peking said. The state should have included in the charge the statutory definition of confidential personal information under 708-800, or at least specified in the charge the items of information that allegedly were unlawfully possessed. So I see that case as standing for the proposition of to-wit clauses, that they can sometimes be an effective substitute for the statutory definition. And it doesn't strike me as that difficult to embed a to-wit baseball bat or to-wit occipital skull fracture or serious concussion. So it seems that we've actually answered your question and told you how to frame these charges. And I'm just wondering why it's not the common practice of your office to follow that guidance.
I agree with you, actually, Justice Edens, and that is my reading of Packwing too. So, whenever a deputy has asked me, like, whether that's what it says, whether the court is saying just add to it, or whether, that would solve the problem, my answer was absolutely yes. Like, that would simplify the matter, but people don't care what I say. Right? That's why we're here. And, I did read it that way, but I don't think it was absolutely clear, or else I wouldn't have other prosecutors asking me that question. And I think it was clear that it did give us, at the very least, an out, that's a way to simplify it, add a to-wit. But then I do have other deputies asking me this, like, is it enough that it's to-wit a bat? Or does it have to be to-wit a bat swung at the head? Or, if there's multiple injuries, as Justice Wilson had brought up, bruising, of course, it wouldn't be the types of injuries that don't comply or equate to substantial bodily injury. But are we gonna be precluded then if we leave out an injury that otherwise we didn't know about. And that's where I wasn't completely sure on that answer. But yes, I do appreciate what you're saying. I'm not saying that Paquin didn't hint to us that that would be one way to solve it. But again, as I had mentioned in my introduction, what we would ask this court, if it's going to say that, yes, that's one way to solve it, in this case, at least, we would ask this court to look at the closing report that was given to defendant in determining whether his right to fair notice was violated in this case. But I appreciate your question.
Very well. Thank you, Mr. Tsushima. Justice McKenna, your question.
Thank you. Mr. Tsushima, you actually raised an interesting point at the end there that you said, what if your office didn't know about another potential substantial bodily injury? And it makes me wonder how a defendant is then supposed to know about it. But in any event, my question is substantial bodily injury a generic term?
In what sense?
Well, in Wheeler, this court said that where the definition of an offense includes generic terms, it is not sufficient that the indictment shall charge the offense in the same generic terms as in the definition, but it must state the species and descent to particulars. And so following up on Justice Eden's lines of questioning, in terms of, and I relate, I'm asking about substantial bodily injury. Let's say that someone gets into a fight and shoves someone, and that other person's leg kind of locks, and that person's knee, there's a tear to the anterior cruciate ligament, a very common sports injury. Is that substantial bodily injury?
Sorry, I heard a ring. I don't know if it falls under possibly the fifth.
Right, I didn't know that either, but you know, one of the definitions of substantial bodily injury is a tearing of other internal organs.
That's the one I'm looking at.
I looked up internal organs, and apparently ligaments are organs. But
that's the one I would have
then
guessed.
my question would be, well, what if instead of a tear to a ligament, it was a tear to a meniscus, the cartilage around the knee? Is that a substantial bodily injury?
I don't know that it is. Again, the only one I would guess would be subsection 5. And if so, I would want to look it up before being sure. I had not looked that up and compared it.
And
I'm not very good with my medical.
Thank you. Those are my questions. Thank you.
Well, thank you, though.
Anything further at this point? No, or do you want to wrap up and then save time for rebuttal? It's up to you.
No, I'll just save time for rebuttal, Chief Justice. Thank you.
Very well, thank you. Mr. Guerrero, your argument.
Your Honor, am I on?
You are. Oh, we can hear you.
My apologies, Your Honor.
Oh, no problem.
Your Honor, can I just take a minute, Your Honor? I just need to use. There we go. Your Honor, Emmanuel, may it please the court, Emmanuel Guerrero on behalf of the respondent appellee, Mr. Jardine. My apologies, Your Honor, Mr. Jardine is not available, but he is participating by watching the YouTube channel. The petitioner's position appears to state that Mr. Jardine was given proper notice. That is not the case. The element of the charge, the result of the conduct was not stated. And it's very, very clear. And the circuit court made that clear, as well as the ICA making it also clear. And The second thing is, even if they tracked the statute where they said substantial bodily injury, they did not provide sufficient notice of the allegations as to what Mr. Jardine would have to defend against in this case. When I read the petition, it appears that the state is saying, well, when you take a look at it, he knew what he was facing. He knew what it was. Your Honor, the Article 1, Sections 5, 10, and 14 requires due process, and 1 requires notice of the elements of the offense that wasn't done. 2, and if that's not done, at least provide sufficient factual allegations that was not done in this case. This court recently in State versus Shaw made it very, very clear. If it's an element of the offense, it must be stated. If it's not stated, at least provide a factual basis. And that's where Justice Eddings, I believe also Justice McKay, I believe all of the court, all of the justices have indicated that maybe perhaps a substantial bodily injury, they could have put down in there the use, the tearing, a broken arm, a broken nose, internal organs being affected. That was not done in this case. This matter was done before trial.
Mr. Guerrero, could I ask, what's your response to Mr. Tsushima's argument that the defendant was provided with discovery, police reports, detailed witness statements, which provided an adequate basis for him to understand the nature of the charge against him? What's your response to that argument?
Right, the burden is on the burden. The state drafted the charge. The state has a big responsibility in upholding the laws of the state. But members, citizens like us, we also have constitutional rights to be informed of the nature of the charge. He was not properly informed. Essentially, what's happening in this case is the state is saying, okay, here is all of the potential evidence. You take a look for what particular facts may be applicable in your case. In other words, they're telling you, in short, look for the needle in a haystack. And that's not proper notice. Let me give you an example. Earlier yesterday, my office is in Chinatown. Because of COVID, I haven't been going in, but I went in. I took a right turn at the stoplight. And, I didn't see the no right turn on red sign. But that gave me notice that it's illegal for me, that I'm going to be charged with an offense of making an illegal right turn on a stoplight if there's a sign there telling me it's illegal to take a right turn. And that's what we have in this case. The state also complains, I believe. They're saying, hey, you know what, it's going to be overly burdensome to do all of these things. It's not overly burdensome. There's 5 specific acts. They could have said broken arm. They could have said skull fracture. With respect to dangerous instrument, they could have said a baseball bat. That's approximately 6, maybe 7 different words. It's not overly burdensome. What is overly burdensome is if you put and you shift the responsibility of figuring out what you're charged with. You as a layperson being charged with, hey, Mr. Jardine, here are the discoveries. Here's the video. Here's the evidence. Figure it out. That's not what it's about. It's about due process of the Article 1, Section 14, Section 10, and Section 5.
Mr. Guerrero, Justice Nakayama has a follow-up question.
Okay, go ahead.
Thank you, Mr. Chief Justice. Mr. Guerrero, doesn't Wheeler say that in determining whether a defendant has been adequately informed of the charges against him, the appellate court can consider other information in addition to the charge? And along with the charge, not just as this, along with the charge was a statement that the defendant used an aluminum baseball bat. So it's not like, and the defendant said he used an aluminum baseball bat. So I don't know how you can say he has to guess as to what the dangerous instrument is when the prosecutors attached it to the complaint. And also attached was the doctor's statement that he had a skull fracture and a serious concussion. So how is that making the defendant guess as to what the injury is?
With all due respect, Justice, the charging document is the felony information in this case. The attachment that you're referring to are the exhibits that the trial court must make a determination whether there's probable cause to support the charging document.
Are you saying that Wheeler's wrongly decided then? Wheeler said that the appellate court can consider other information that was provided for the defendant, and this one was provided to the defendant.
Well, I respectfully disagree. The Wheeler court tells us that if the term is not commonly known, then it must be stated. It must be defined. And I don't think there's any disagreement here that the statement of some substantial bodily injury, or even a baseball, even a dangerous instrument, they're two totally different things. The statutory definition is very specific, 5 different types. And that's the conduct aspect of it. The dangerous instrument, again, likewise, it is very statutorily defined and specific. So the Wheeler court tells us that if it is not commonly known, then it must be stated. If it's an element of the offense, it must be defined. It was not defined in this case. Then the second aspect of it is, regardless of that, does the charging document state the factual basis? It does not. Hawaii Rules of Penal Procedure 7 makes it clear. It has to be concise. And again, it goes back to the state apparently saying, it's going to be overly burdensome. It's going to be very difficult. It's taking up a lot of time. It does not. They can pick 1 of 5. They can say it. And in this particular case, I don't know why they haven't done it. I mean, the cases that we have, the court's cases have repeatedly admonished all the parties. Defendant has a constitutional right to be provided notice. The state has the responsibility, duty, and burden of bringing the charges. I'm not going to recite all of the cases because I think the court is well versed. The last one I saw, not the State versus Shaw, but the Baker case. And that was a very contentious case. I know that the court, there was multiple issues about whether Ms. Baker received proper notice by the charging document. And the court specifically stated, if it's an element of the offense, it has to be stated so that the defense, the accused can prepare a proper defense. That's due process. Finally, the state appears to rely on Manoa, the unpublished summary disposition order. I think in this case, the Jardine case, it explicitly tells us that the Manoa analysis was wrong. And I think if you take a look at the author of Jardine, one of the authors, one of the panel member was Justice Leonard. She was a justice in both cases. So I think the ICA themselves finally realized, you know what? It is an element of the offense. All of the cases that the Supreme Court have cited, have provided, tells us Manoa was erroneously decided.
Mr. Guerrero, if I could, Justice Wilson has a question, but I do want to follow up on Justice Nakayama's discussion. In Wheeler, we were talking about the Treat case where we said where discovery had been supplied to the defendant. In that case, the defendant had been supplied with a grand jury transcript, which clearly established the details of the crime and thus had been fully informed of the nature and cause of the accusation against him. So we acknowledged an earlier case of the State versus Treat that suggests that where discovery, which has details about the crime, has been provided to the defendant, that can be taken into account in determining whether there's fair notice or not. Again, I want to ask, are you suggesting that those cases are erroneously decided and we should overrule them? Or are you suggesting that in some sense the discovery given to your client here was not adequate?
I'm not suggesting either, Your Honor. I'm Chief Justice. What I am saying is Baker, the line of cases tells us that if an element of the offense is not listed in the charging document and you file a motion before trial, the charging document is defective. That is what I am saying, and that is what the ICA have ruled on. And this is what this court have made it very clear. Because if you take a look at the Baker case, hey, they went to trial. You know, the Model Wells, the liberal standard, they went to trial. They had all of the facts.
All right.
Mr.
Guerrero,
Justice, can we get someone to turn off? Maybe whoever's not speaking can be muted so the bings on the text tones are not heard so constantly.
We're hearing a tone that's coming across, so I'm not sure if someone's phone is on, but Mr. Guerrero, we need your mic on and whoever's asking the questions, obviously, but if it's your phone, if you could, whoever's phone it is, please turn it off. And
phone is off, Judge.
All right, thank you, Mr. Guerrero. Justice Wilson has a question.
Thank you, CJ. Mr. Guerrero, I know you have focused on the issue of whether or not your client received adequate notice, but specifically now that we've heard from Mr. Tsushima that there were a couple, in his view, there were a couple of possibilities in terms of the categories of assault and second-degree substantial bodily injury that could be charged. In your view, what would have been adequate notice? Would it have been sufficient for one of the 5 different categories of substantial bodily injury, assault second, to be identified? Or is it your view that there needed to be some reference to facts as well?
Well, the reference to the facts, Your Honor, Justice Wilson, would be, in fact, what the result of the conduct is. So they could have inserted a broken arm, a broken skull, something that would meet the statutory definition. And in this case,
so in your view, it wouldn't be necessary to identify the provision of the definition of substantial bodily injury. It wouldn't be necessary to identify one of the 5 provisions that are in the definition. A factual reference would have been sufficient.
Well, so long as the factual reference, in fact, is accurate with respect to the statutory definition. As I believe Justice McKenna has posed the question, what is a ligament an internal organ? What about a big bruise? I believe it was Your Honor that said, what about a big bruise? Is that substantial? So the state would have to simply provide notice as to what statutory definition they are alleging, so that the accused can properly prepare a defense in his or her case. And that is the situation that we have here. So I'm not sure how else to answer Your Honor's question. Because let's take a look at the conduct itself, the result. It's a felony. Now, if it's assault in the 3rd degree, any injury. And that's why in the Shaw case, the recent Shaw case, the amount, the degree of items taken or the value taken caused the offense to be greater. And that's the situation that we have here. So, you know, talking about the baseball bat itself, if that's the dangerous instrument, you know, the dangerous instrument in itself has another provision of serious bodily injury, which was not defined in this case. Reading the state's position, I had a difficult time determining whether their main issue is it's going to be overly burdensome to the state. It appears that the state, reading it, they appear to be complaining, saying that, you know, look at the confidential information case, the Pekin, the Shaw, the continuing course of conduct, the true threat. That's just too much. You know what? That is their responsibility. It's their responsibility. They craft the charging document. So they have, it's not that, I'm not saying it's not that difficult, but it is their responsibility, and the Constitution requires proper notice. And in this case, it's twofold. The element was not provided in the charging document. And two, even if assuming substantial evidence is sufficient, the factual basis so that Mr. Jardine can adequately prepare a defense was not provided. Their argument is, we gave you all the discovery. Take a look at all the discovery. You should know by looking at this discovery. This is not a trial. This is not a sufficiency of the evidence. This is Article 1, Section 5, Section 10, Section 14, the right to due process. And in this case, Mr. Jardine's right to due process was clearly violated. So unless the court has anything else,
Mr. Guerrero, do you think there's a point, is there a valid point raised by the state that at some point the charge can become so complex that it really isn't providing fair notice because it's just so difficult to follow all the definitions if they're multiple ones or they're very complicated, that it really isn't doing its job of providing notice? What's your reaction or response to that?
I don't think so. That's their job. The statute is clear. Taking a look at this case specifically, the substantial bodily injury is defined succinctly. There's 5 different definitions. It's not 100 words. It's not a white-collar crime. The dangerous instrument, likewise, we know that a firearm per se, but it's also made it very clear that any object can be a dangerous instrument so long as you qualify it by providing notice that that particular tangible object that you have may cause serious injury. That's not, I'm not saying that's difficult, Your Honor, Chief Justice, but it seems to me that substantial bodily injury, if they picked anyone, could have been 2 words, 3 words. Now, if you take a look at the Baker case, the Celeste Baker case, that's a long one. That was a long complaint. Take a look at the confidential information case. That is a long one. So speaking specifically for this case, no, it's not a burden to the state. And for the state to complain that, hey, you're making our job very, very difficult. It's not about the state. It's about the citizens of the community, and it's about the Constitution. If they have a problem with the language of the statute, go to the legislature. But if you have a problem with the Constitution, that's something else. I mean, the Constitution is very simple. Article 1 is very short. Excuse me. Article 1, Section 5, 10, and 14. They're very short. Substantial bodily injury is very short. Dangerous instrument is very short. So I don't see how they can complain. If they're going to complain like that, Judge, Your Honor, don't be a prosecutor. If you're not going to follow the Constitution and provide proper notice, do something else.
Well, the question, Mr. Guerrero, is at some point, is the definition or the charge so complicated? And even if, we have to think about other cases that are going to come down the road, like the confidential information case, where we indicated as an alternative, you could say to it. So how would you say we should handle, what kind of rules should we adopt so that when we do have a case that is a very complicated definition, that we're providing meaningful, understandable notice to the defendant? Do you have any suggestions there?
I guess one way could be, excuse me, Your Honor. First of all, we have to recognize that a defective complaint fails to state an offense. So an alternative way, and I do believe, I don't quite recall, but I do see it in one of the cases where I think the court suggested maybe they can just incorporate the statute somehow as an appendix to the charging document itself, making it clear that this is the specific statute in full or in pertinent parts. But going back to this case, this is not one of those situations. This situation is, I'm not saying it's clear cut, but when you take a look at it, it's one of those cases where there was no burden at all on the state, overburden on the state to properly provide notice. So I don't know how else to suggest it otherwise. My suggestion would be go to the legislature, work up a rule with all parties, all interested parties, and make a determination as to what will be proper. And this court has done that many, many times. The right to jury trial, for example. Ultimately, the court said, okay, you know what?
We're getting the tone again. I'm sorry.
I'm sorry, Judge.
No problem.
Okay.
Justice Wilson has a question. So
Okay.
yeah, thank you.
Mr. Guerrero, the circuit court dismissed the case without prejudice, which clearly meant that the government could bring the charge again, perhaps in a more complete form. Just want to be clear, the remedy that you're looking for is the filing of a new charge that comports with the requirement that the defendant receive adequate notice of the charge. Is that right?
Well, Justice Wilson, the Judge Nakasone dismissed it without prejudice. We did not challenge that. We did not file an appeal on that. And as a matter of fact, quite frankly, we anticipated a refiling of the charge, which never occurred. And again, that's the state's prerogative. The state's prerogative. They were actually given an opportunity. Hey, Mr. Prosecutor, this is not sufficient. You got another opportunity. Rather, they chose this route. And we did not challenge the dismissal without prejudice because we knew that, well, the extension factors appears to favor them at that point, and I will concede that. But it is the state that elected another course of avenue, and that's why we're here today. And the thing about their course of avenue on this writ is they appear to be saying two things. Manoa was correct. And even if Manoa was wrong, it's too big of a burden on us. That's what they're saying. You know, that is their responsibility. That is their duty. There is their job. Just as my job is to zealously represent my client, just as the job of the court is to make a decision without interest to any respective parties, but to follow the law. And that's the law that we have. It's not a situation where defense waited till trial or the middle of trial like Manoa. In Manoa, they raised that issue at the close of the state's evidence. That's not the case that we have here. In Baker, it was raised on appeal. We gave early notice providing to the state, hey, there's a mistake here someplace. This Hawaiʻi state constitution has been violated. Do something. You know, at that point in time when the motion was filed, they could have simply filed an amended felony information or filed another felony information. That's not what they decided to do. They're steadfast saying, no, we're right. Notwithstanding Baker, notwithstanding Wheeler, Nesmet, Kauhani, all of those line of cases, we are right. And we're going to prove that we're right because we don't want to draft the documents in such a very, very specific form because it is too burdensome. And my response to that, Your Honors, with all due respect to my candor and my kind of frustration, if you don't want to, if it's too hard, don't do it. Go someplace else, do something else. I'm not saying that that's what happened in this case. I respect their position. But essentially, when I read their petition, that's what it appears to be. But I do know that's not the situation in this case. But when they're looking at it, a layperson looking at it, they would think, how come they don't get it? And we as layperson, when we say, how come they don't get it? It's either everyone is wrong and I am right, or I am in fact just not getting it. Broken arm, fractured skull. Burdensome? No, because they could have put it in. They did not. They put it in the exhibit.
Mr. Guerrero, Justice McKenna has a question.
Yes.
Just a quick question, Mr. Guerrero. Do you know what the other circuits are doing? What are the other prosecutors' offices doing? Do they include which provision it is in the charging instrument?
I can tell you for the last 2 years, the Fifth Circuit, they've been doing it. We have a couple of cases on appeal, I believe. And rather than filing an appeal, what they've done now is amending their information and listing all of the statutory definition. And that's
every single one? Doesn't that cause more confusion than necessary?
No.
How is a defendant supposed to know which one applies then?
Well, that's
I know that in State versus Kodiamat, we said that we can a charge can be in the disjunctive.
Yes.
But if a subsection of includes like 5 or 6, how is the defendant supposed to know which one applies to him? Or
you are correct, Your Honor.
the defendant?
I mean, they should be very specific, but in response to your questions, I've had several cases where they've actually defined what they're alleging after we filed motions. State versus Michaelides, we've just done that. I believe it's up on the ICA at this point. State versus Lealoha, there's several cases. And what the state, at least what the Fifth Circuit has done is they've amended charges. And with respect to the First Circuit, I did have another case similar to this where the charge is sex assault in the first degree of sexual penetration. And the trial court did grant the motion to dismiss because they did not specify what kind of penetration it was. And right after that, rather than filing appeal, the state obtained an indictment alleging the specific act of penetration. And so yes, on State versus Alero, I believe that's unpublished case. Many cases where they're stating what missing statutory definitions, what statutory definitions are missing from the charging documents.
Mr. Guerrero, you're almost to the end of your time. I wanted to give you a chance to wrap up if there's anything further for the court.
Yes, I'd like to thank the court for this opportunity to appear before the students, the high school students. And unless the court has any other question, I would ask the court to affirm the decision by the ICA. It was well reasoned, albeit a summary disposition order, because it made it very clear the common definition is overly broad. And I think the state has conceded that point at this point, regardless of what they say. From listening to their portion, I think they concede that. And thank you, Your Honor. I have nothing further. Thank you very much.
Very well. Thank you, Mr. Guerrero. Mr. Tsushima, your rebuttal. Mr. Tsushima, you're on. You need to unmute.
I apologize for that, Chief Justice.
Thank you.
About that. As this court is well aware, I'm not a man of many words. I do believe the points I wanted to make this morning were made. The only thing I wanted to say is, contrary to what Mr. Guerrero was saying, the state's not complaining about anything. We haven't at all in this case. We're just asking for clarity by this court on the issue. Actually, if the court doesn't have any questions, I just as well just wish the court happy holidays and to all the justices.
All right. Thank you to both of our attorneys for your arguments today. The court will take the, Justice Edens, I'm so sorry. I didn't see that you'd asked. I apologize. Justice Edens, your question.
No, that's okay. And thank you for those final remarks, Mr. Shima. I think all of us want to have a holiday season, but sorry, I do have one last question.
Sure.
And it sort of touches upon almost your first sentence you mentioned during this oral argument about the discovery. And so, it strikes me that if a charging document omits the essential facts necessary to constitute the charge, and that's right in Rules of Penal Procedure 7D, if they omit that, there's a problem. But what you seem to suggest is that if they get discovery, that will cure the defect in the charge and the fact that it contravenes Rule 7D. Am I correct in that understanding?
I won't say in every case it's going to correct the situation. In this case, I'm going to say it does because it was laid out so clearly. As Justice Nakayama pointed out, through the doctor's statements of what the injury was, specifically Dr. Victor Lau had stated that Paul's injuries were a fractured skull and serious concussion. In fact, Dr. Yashu's statement in this case was Paul's injuries were substantial bodily injuries. Following that, it says Paul was diagnosed as having skull fracture and serious concussion. And then I just want to finish what I was going to say. Under the heading weapon used, it specifically says that the defendant used a metal 34-inch baseball bat to hit Paul on the left side of his head. So in this case, I'm going to say that yes, for this court to look at the discovery, and yes, it will show, I'm confident that defendant was given proper notice under these circumstances. Not in every case.
So the charging document could just omit elements. It could, and it's just cured by the discovery. Am I correct in that understanding of the position?
That it can, that when the claim is that the defendant wasn't given proper notice, that this court can look outside the four corners. So it will be an error for us to have done it, but that it can cure it because what the court's ultimately concerned is, did the defendant have fair notice? That's the question. You would state, it would be part of the process to state that the indictment was flawed. But as to the issue of whether his right to be informed of the charge was violated, then looking at the other materials that's before the defendant, this court I would suggest would conclude that it was not violated for that reason.
Thank you, Mr. Shima. And thank you once again for a very professional presentation on your part. Thank you, Mr. Shima.
Thank you, Justice Sutton. I appreciate that.
All right. Well, thank you to both of our attorneys, Mr. Tsushima and Mr. Guerrero, for participating in our program today. The court's going to take this matter under advisement, which means we'll be issuing a decision at a later date. But I did want to thank the many people who came together to make it possible to have this program involving the students who are here with us today. And of course, first and foremost, I want to thank the students and their teachers who joined us today from Aiea High School, Moanalua High School, and Molokai High School. You know, the future of our government depends on the public understanding the Constitution and the protections it provides, and really the dedication and hard work that these students put into preparing for today, and their students and their teachers in welcoming attorneys into their courtrooms to help prepare them for the argument really shows their commitment to understanding our system of government and that we're in good hands going forward. You know, my colleagues and I recently participated in a national conference by an organization called the American Judicature Society. We heard from a number of speakers, including Supreme Court Justice Sonia Sotomayor, about the importance of civic education to the future of our democracy. And I think that this program and these students who are participating in today are really a great example of civic education, and it's at its most effective and really doing the most sort of presenting in the best possible way and in a way that really fosters learning, the understanding of our Constitution. So I want to thank the students and their teachers, and then the many people who helped to make this happen. First and foremost, the attorneys from the Hawaii State Bar Association, the Maui County Bar Association, who, as I said, volunteered to meet with the students, conducted sort of mock or practice arguments so that they could understand the issues. And I really appreciate each and every one of those attorneys. And then I want to thank Levi Ho'okano, the president of the Hawaii State Bar Association. who's going to be our MC and moderator today. The Kamehameha V Judiciary History Center here downstairs in the Supreme Court building for developing the curriculum for the students to help them understand the case, as well as the William S. Richardson School of Law for training both the teachers and the volunteer attorneys about the issues in this case. And then the many people who came together to support this program from a technical perspective, our bailiff, Kurt Shibata, and all of the IT staff at the three schools I mentioned who've come together. Finally, I want to thank Rebecca Copeland and the Bar Associations for coordinating the volunteer attorneys and today's lunches, and the Hawaii State Bar Foundation for their generous financial support of the lunches that people will be provided today. And finally, mahalo to Olelo for producing and broadcasting today's oral argument. So once again, thank you everyone, and there being no further business, this court stands adjourned.
Ua.